Hi, my name is Ryan Fowler and welcome to the Offshore Asset Protection and Investing Secrets video series. This is part 3A. We're going to talk about offshore LLCs, what they are, their fundamentals, and compare them to offshore asset protection trusts and how they stack up to them. A little bit about myself. I am an asset protection, estate planning, and global investing consultant. I have a nationwide clientele. Their net worth ranges from about $200,000 to over $100 million. And I'm the author of Asset Protection in Financially Unsafe Times. It's co-authored with Dr. Arnold Goldstein. It's a bestseller in its class on Amazon.com, and it's also the highest reviewed book of its type on Amazon.com. So let's go over the basics of offshore LLCs. An LLC stands for Limited Liability Company. It's actually not a corporation. It's distinctly different from a corporation, although it carries some of the same characteristics as a corporation. An LLC is a business entity, so you need to know it is not for holding non-business assets such as jewelry or artwork. It's okay to hold investments if those investments are giving you some type of return or profit, because that's business activity. The thing that, and there's a quote there for you that talks of, this is a California bankruptcy quote where a judge talks about why business entities cannot hold non-business assets. The best thing about offshore LLCs is that they have charging order protection. Charging order protection means that a creditor of an owner of an LLC may not seize LLC ownership, they may not gain control of the LLC, they may not seize LLC assets or get assets inside of the entity. The good thing about LLCs is they are more congruent with United States law than offshore trusts. Charging order protection is actually found in the laws of all 50 states in the United States. So it's a staple of U.S. law. That means it's more likely to be respected by a U.S. judge, this charging order protection, except now you also have the extra benefit of having your assets offshore, so it's an extra layer of protection being outside of a judge's jurisdiction. Compare that with offshore trusts, where most states do not allow self-settled trusts. A self-settled trust is where you put assets in the trust, but you still benefit from those assets. You're both the person that funds a trust, called a grantor or settler, but you continue to benefit from those same assets. And there's a statute there from the California Probate Code that basically says if you do that, creditors can get assets in the trust. So in the United States, no asset protection for self-settled trusts, but offshore trusts are self-settled. So it's somewhat in conflict with U.S. law, although it's offshore and outside of the judge's jurisdiction. There is one misconception about LLCs, foreign LLCs, and that is some people say that LLC assets may be attached if a judgment is entered in the LLC's foreign jurisdiction. That's just flat out wrong. The only time someone can do that is if they have a reason to sue that LLC directly. And if your LLC is offshore, it's not doing business in the United States, there's not going to be any reason for anyone to sue that LLC directly. They don't have what's called proximity to the LLC to sue it directly. So if they can't sue it directly, they cannot get assets inside of that. And there is a court case on the PowerPoint, Garcia versus Kaufman, that'll probably come up if you Google it. You can read about the doctrine of proximity to kind of dispel this myth. Properly structured LLCs, they're never sued directly, cannot be, generally cannot have the assets inside of them confiscated. So, more comparison, offshore trusts versus offshore LLCs. LLCs are less vulnerable to fraudulent transfers. A fraudulent transfer means if you transfer your asset into an entity so as to get that asset away from the creditor so the creditor cannot get it, if a court can prove that's why you did the transfer, then the asset protection plan is vulnerable and it can fail. With offshore, we get a little extra insulation even if you get a fraudulent transfer ruling, because the assets are outside of the judge's jurisdiction. You still may have protection. But in fraudulent transfer law, if you put an asset into an LLC, you get something of equivalent value back, and that is you get an ownership interest in the LLC. That actually makes it less likely that what you did will be seen as a fraudulent transfer. But when you put assets in a trust, it's a gift. You get nothing back under fraudulent transfer law, and that's much more vulnerable to a fraudulent transfer ruling. So offshore LLCs normally fare better under a fraudulent transfer law analysis in offshore trusts, and that's something to keep in mind. More comparison, offshore trusts versus offshore LLCs. I'm not going to go into detail on this, but this is the actual fraudulent transfer law that talks about gifts versus exchange of equivalent value, and why exchange of equivalent value are better. In the next video, we're going to talk, in the series Offshore Asset Protection Secrets, we're going to talk more about offshore LLCs. We're going to talk about how to set up the management of them and the best jurisdictions to form them in. So we'll see you in the next video. So if you found this inside information helpful, be sure to get the complimentary ebook version of Asset Protection in Financially Unsafe Times, and also get the free video tips series emailed to your inbox, and also find out for a limited time only how you can have a 20-minute consultation with me so I can answer your questions and discuss solutions for your specific situation. You get all this for free. Just go to www.offshoreassetprotectioninformation.com and sign up. I'll see you there.